Good morning, afternoon, evening, everybody. My name is Leon Trackman. I'm the chair of this session, and I'd like to acknowledge the, unfortunately, my system's gone down, so I'm basically using notes that you have. I'd like to be able to go through the presentations and briefly, but I'd like to start off by welcoming you by indicating that this is an opportunity to be discussing something of very great significance in our current time. And and then I should just mention a couple of things. The first is I'd like to begin by acknowledging the traditional custodians of the land on which we meet today. I'd also like to pay my respects to the elders, both past, present, and emerging. And I'd also like to thank the speakers for excellent papers that they've circulated in advance. And then very briefly, just to give you some basic rules, as you reach the end of your presentation, I will put up my finger. That is not an insult, that's just, I'll put up that finger if you like, which basically means 1 minute to go. And that would effectively give you a sense of how much further you need to say. I could do it earlier, but I thought 1 minute might work. So we have a very tight timeline. In terms of the topics themselves, I think they're all tied together to some extent by certain common denominators. The one is the current reality, the COVID-19, the fact that you can view it through many different prisms. Of what we've chosen to look at has been the primary focus on the nature of its occurrence and impact, particularly as a determinant of how we resolve disputes, and in particular how we recognize changes in our process of engaging in investment. And that's of course highly complex. Some people would say nothing's really changed. Other people would say there's a radical transformation in the manner in which we function. Okay, to go on directly to the first presentation, I'd like to introduce you to Kahinda Olawi, and her paper is entitled Force Majeure Clauses, Investor-State Contract Disputes, and the COVID-19 Pandemic. In terms of bio, Kahinda is completing a PhD in law at the Chinese University of Hong Kong. Her doctorate dissertation focuses on the distinct trends and dynamics of foreign investment law in West Africa. Prior to her doctoral studies, Kahinda completed degrees in law at King's College London and the University of Ibadan in Nigeria. So I'll hand you over to the capable hands of Kahinda, who will begin her presentation. Thank you.
Good afternoon, professors and colleagues. It's an honor for me to participate in this year's Young Scholars Workshop. In the next few minutes, I will present on force majeure clauses, investor-state contract disputes, and the COVID-19 pandemic. My presentation argues that disputes arising from investor-state contracts occupy a unique space where contractual provisions may intersect with international and domestic law. Essentially, I argue that even though most investment treaties adopt war clauses and increasingly public health defenses, in practice, an investment contract force majeure clause will provide more adequate protection for both investors and host states. My presentation is divided into three main parts. First, I will discuss the uniqueness of force majeure clauses. Second, I will give a brief overview of existing practice. And lastly, I will discuss future directions. As we all know, the world is facing an unprecedented health crisis. This has also resulted in significant economic losses for states, corporations, and individuals. One of the key issues which has emerged in the wake of the crisis is the effect COVID-19 will have on international investment law. International investment law, IIL, is a field of international economic law which basically regulates the relationship between foreign investors and host states. And it does this through three main mechanisms. First, national investment laws. Second, international investment agreements. Basically, international investment agreements are agreements that are signed between two or more states which protect investment of nationals of the other contracting states. So, for example, the China-Sweden Bilateral Investment Treaty of 1982 protects nationals of China investing in Sweden and vice versa. The third mechanism of international investment is investor-state contracts. My presentation focuses more on this third mechanism. Investor-state contracts are agreements signed between foreign investors, including state-owned enterprises and host states for various purposes. For example, a Chinese SOE may sign a joint venture agreement with a state for the extraction of bauxite. Unlike investment treaties and national laws, investment contracts adopt very distinct clauses. However, a common feature of investment treaties and contracts is a dispute settlement clause, which usually gives a foreign investor the right to enforce obligations through arbitration and other means. In a particular instance, a dispute may be purely contract-based, purely treaty-based, or purely based on national law. In many instances, a dispute may come under two or more of these regimes. So, for example, a contract between an Australian investor and China may also be regulated by an investment treaty signed between Australia and China. This will be determined on a case-by-case analysis and will depend on the applicable law of the contract. One unique clause which has been transplanted from national regimes is the force majeure clause. In simple terms, a force majeure means exceptional circumstances outside the control of parties which make performance of the agreement almost impossible. So an epidemic like COVID-19 is obviously a force majeure event. Unlike other defenses that we find in investment treaties and under customary international law, in practice, the force majeure clause operates very differently. I will now move to the second part of my presentation. For the purposes of this presentation, I have reviewed force majeure clauses in investment contracts. I have also reviewed cases which have involved force majeure pleadings. Undertaking this review is important for two main reasons. First, one of the main arguments that has been made is that states will face an increasing number of investment disputes relating to COVID-19. Second, unlike other areas of international law, principles regulating state responsibility for contracts have arisen from arbitral decisions. It is thus striking that there have been very few investment treaty or investment contracts relating to force majeure. This may be because of the nature of investment arbitration. Also, usually the foreign investor has more obligations under the agreement, and in practice, it is the foreign investor rather than the state which usually gives a notice of force majeure. Some of the findings that I have encountered: first, contracts that were signed in the 1950s and the 1960s defined force majeure as occurrences recognized under principles of international law. Investor contracts have, however, become very sophisticated, and the force majeure clauses that we find in most investment agreements are based on modern sales contracts and the Hague Convention of July 1, 1964. Some clauses provide for recourse to arbitration in event of a dispute between the parties as to the existence of force majeure. Under a few contracts, parties have a responsibility to notify the other party where there is a force majeure event. Also importantly, some contracts provide for possible termination of the contract if the force majeure occurs for more than one calendar year. Generally, tribunals have held that force majeure does not extend to payment obligations or economic crisis. and the jurisprudence reflects some of the principles I have highlighted above. In the cases I have reviewed, the force majeure was applied more readily in contract-based disputes. In very few cases, tribunals made a distinction between force majeure as a breach of an investment treaty and as a contractual breach. With a caveat, I will state that there are no publicly known investment treaty claims where force majeure has been used successfully by a state as a defense. This may be because tribunals favor an approach which focuses on force majeure as an event which merely suspends the performance of the agreement. The main question then will be, when does a first force majeure event end? By notification. But how do we determine when the COVID-19 ends? Other procedural issues will include the applicable law, the causal link, and rules of attribution. In all, this will depend on declarations of the World Health Organization and declarations of states. I will now end my presentation with a few words. Predictability and certainty are at the heart of modern international investment law, and COVID-19 challenges these principles. Nobody knows when exactly this will all come to an end. It will have an impact on contractual obligations, contracts to be renegotiated, and the rights of third parties will also be affected. The force majeure clause first emerged in the context of direct expropriation and war. My presentation has shown that investment contracts may be more suitable for protecting interests of both parties during and after epidemics. Overall, I don't think that there will be many successful disputes relating to COVID-19 or the force majeure clause. However, I believe that one major effect is that states and contract parties will negotiate contracts and treaties which adequately spell out the obligations of states and parties when there is a virus outbreak or an epidemic. Thank you very much for listening to my presentation, and I look forward to receiving your comments and questions.
Many thanks, Gandhi. It was a very good presentation, and I'm sure you'll have lots of questions. I'd like to introduce your primary commentator, Dr. Brooke Marshall. Brooke is a lecturer at University of New South Wales in law. She researches in private international and comparative law, focusing on French, German, English, and EU law. She's a recipient of the diploma of the Hague Academy of International Law. Prior to joining the University of New South Wales, Dr. Marshall was a senior research fellow at the Max Planck Institute for Comparative and International Private Law in Hamburg, where she completed her doctorate summa cum laude. She'll visit the Institute for European and Comparative Law and St. Catherine's College at the University of Oxford in 2021, which is a lot ago. Sorry, outside of academia, Dr. Marshall has worked as an associate to the Honourable Justice Keane while Chief Justice of the Federal Court of Australia, as a litigation lawyer at Allens, Linklater's, and of the intergovernmental organisation, the Hague Conference on Private International Law in the Netherlands. Dr. Marshall, please proceed. Thank you.
Thank you, Professor Trackman, and thank you very much, Ms. Alawi, for this fantastic presentation. Of course, you're dealing with a topic that is of extreme importance to us in this strange new world in which we find ourselves. And really, the central question you're dealing with is one which goes beyond investor-state disputes and affects private legal persons, state-owned corporations, or any combination of these in dealing with the economic fallout of a global pandemic. Now, what I propose to do in my comments is two things. Firstly, to outline what I understand to be the central premises that you're challenging in your piece and your central arguments. Questions to you, which I'd invite you to answer after I've completed my comments or during the Q&A session. So the first premise you're challenging is the prediction in the literature, including in the 2020 World Investment Report, that the pandemic will lead to a significant increase in international arbitration disputes between foreign investors and host states, and that foreign investors will bring claims against states to recoup damages suffered as a consequence of the pandemic, You also challenge the view propounded in that literature that the necessity defence or the necessity principle under international law and force majeure clauses can be treated as conceptually analogous. And I think that's a very interesting idea, which I'd invite you to elaborate on. And what I understand to be your central argument is that force majeure clauses in investor-state contracts provide better protection than the protection provided for under bilateral or multilateral investment treaties. And you suggest that this protection is superior both for investors and for host states alike. And the reason for that superior protection is on account of the applicable law governing investor-state contracts as opposed to investment treaties. And I'm interested, and this brings me to the start of my questions that I'd like to pepper you with. What is the basis for this particular distinction? Why do you think that the treatment under investor-state contracts for investors and for host states is superior to the protection that can be offered under the investment treaty regime? And when you're talking about national laws, what are you talking about here? And why are those national laws superior to the equivalent system that we have under the bilateral or multilateral investment scheme? I'm interested in knowing why you suggest the protection is equally attractive both to investors and host states, if, as you mentioned, investors have typically been the parties that have relied on force majeure clauses in the past. And I wonder whether that historical reliance might suggest that these clauses are actually more beneficial to investors than to states. I think too that there are a number of questions which fall for consideration in relation to force majeure clauses in the investment context when we're dealing with COVID. Now, insofar as domestic law applies to them, of course, we have a whole range of different domestic law approaches to force majeure, which differ from one system to the next. So I think a useful starting point for a base idea relating to force majeure from the perspective of national legal systems is the recent guide produced by UNSW on force majeure in international commercial contracts and dealing with the COVID-19 pandemic. Those UNSW principles on international commercial contracts are obviously a reflection of the national laws of a number of different legal systems, and I think these provide a good starting point for assessing how force majeure under national contract laws might apply to investor-state contracts. Now, it seems to me that some of the elements suggested in this particular guide for how we apply force majeure principles in the context of the pandemic are difficult to transpose from the context in which those principles were created, so a context involving two private parties, to a context involving one semi-private party, so a state-owned corporation and a state. And just to take one example from these principles. So these principles suggest that the act arising out of the pandemic, which is beyond the party's control, must be a mandatory measure. So a mandatory measure in the context of a private-to-private contract would be a measure imposed by a state rather than a recommendation, which renders one party's performance impossible. Clearly, where the state itself is the party to the agreement, what is our starting point? How do we adjudge what mandatory means when it is the state, in fact, deciding whether or not that measure needs to be taken? And perhaps you might like to answer these questions or consider this idea of how we adjudge whether something is mandatory or not by considering the force majeure clause which you outlined in your outline piece, which is the clause in the concession agreement between the China Power Investment Corporation and the Republic of Guinea. And so that clause, for everyone's benefit, provides a case of force majeure means any event, act or circumstance that is unpredictable and beyond control or beyond the control of a party, and which significantly
can I interrupt you a second? It's actually 5 minutes
to execute part of its obligation. Pardon, Professor Trackman?
Yeah, sorry, it's a 5 minute, not a 10 minute. So maybe if you could just round it off, and then if Kehinde can keep those questions for later. Sorry, there was possibly a mistype on the documentation. So sorry about that.
Yeah, so perhaps you can think about those when thinking about how you might think about that particular clause when thinking about these sorts of issues during the Q&A. There are a great number of other questions, I think, which arise in this context, but it's certainly a very relevant topic for discussion. So thank you very much for your presentation.
That's great. Thanks very much, Brooke. Thank you. I'm now going to introduce you to Ms. Apeksha Chauhan of Trade and Fiscal Policy Division, Ministry of Commerce and Industry in India. Her paper, the abstract, is Global FDI Restrictions Post-COVID-19, Maintaining National Security or De-accelerating Globalization. Can I introduce by your first name? Apeksha is currently working as a legal consultant with the Trade and Fiscal Policy Division under the Ministry of Commerce and Industry in India. Prior to that, she worked as a research fellow at the Center for Trade and Investment Law, which is a think tank under the Department of Commerce and Government of India. While pursuing her master's in law at the National Law Law University, she worked as a teaching assistant for international investment law to final year law students. During her time at the Center for Trade and Investment Law, she worked closely on various free trade agreements and the WTO disputes. It's a pleasure to welcome you, Apeksha, and please proceed with your presentation. Apologies to everybody for that. Technical. Okay, so what I'm going to do is go on to Nicholas Strain at the University of Oslo, and it's, I think, very late at night. No, I'm not mistaken. Title is Assessing Emergencies Before Investor-State Arbitral Tribunals. BITS fit the purpose to address global health pandemics, and that's a question. So effectively, now Nicola is a doctoral research fellow at the Pluricourt Center at the University of Oslo. She's working on an interdisciplinary research project evaluating the legitimacy of international courts and tribunals, as well as completing her doctoral thesis on the jurisdiction and applicable law of the WTO and investment tribunals. Nicola holds a Master's of Law degree at the University of Cambridge and completed her undergraduate legal education at the University of Western Australia, a Bachelor of Arts and Bachelor of Law. Nicola is also an experienced lawyer, having worked for Clayton Dutz prior to commencing her PhD. Nicola, please do proceed. Thank you very much.
Thank you, Professor Trackman. And also thank you to the Centre for allowing me to present at today's Young Scholars Workshop. So good morning. Well, good morning for, it's quite early in the morning here in Norway, and good afternoon to those on the other side of the world. So today, my research today is concerned with, it comes about from this concern with the influx of potential investor-state disputes that may arise from the regulatory measures that states are bringing in to address the global pandemic. What I'm particularly concerned looking at the investor-state disputes under sort of bilateral investment treaties, particularly in relation to the sort of the older style BITs that often don't include sort of specific public policy exceptions, and they leave a lot of room to the tribunals to interpret and sometimes fill gaps where these such exceptions and greater sort of detail on the obligations of states and investors don't exist in such BITs. So what this potential, this room for the tribunals could lead to in relation to the influx of investor-state disputes following the pandemic is this potential for fragmentation, and increasing fragmentation both between investment law and global health law, as well as the fragmentation between tribunals, or also we might call the inconsistency between tribunals. So in this way, my research is sort of like an exploratory approach to looking at some of the potential sources of fragmentation and how we might need to consider these sources of fragmentation, both when states and investors are arguing these disputes in the coming future, as well as how states might need to consider amending their BITs in the future to address some of these public policy exceptions and the fragmentation concerns. So my presentation is split into 3 parts. First of all, I'll be looking at sort of the intersection of global health law and investment law. And in this part, I'll be looking at what global health law instruments may be relevant to investor state and what powers adjudicatory tribunals have to consider these instruments. Secondly, I'll be turning to look at the sort of the first mechanism under which global health can be brought into an investment dispute through the regulatory powers doctrine. And we'll be looking at what guidance we can get from the Philip Morris versus Uruguay decision in this regard. And then the third part of the presentation is looking at the plea of necessity, both under the customary international law and under the BIT exceptions. And here with particular concern is relation to the inconsistent jurisprudence on the necessity defense arising from the Argentine financial crisis. So turning to the first part of my presentation, the intersection of global health and investment law. So here, it's particularly relevant will be the international health regulations, which are a binding international instrument which states as its objective to prevent, protect against, control, and provide a public health response to the international spread of disease in ways that are commensurate with and restricted to public health risks and which avoid unnecessary interference with international traffic and trade. So under the international health regulations, the Director General of the WHO may declare a public health emergency of international concern, which enables the WHO to issue temporary recommendations to states. And in fact, the WHO, as we know, has declared a public health emergency of international concern and has issued such temporary recommendations. So these temporary recommendations, unlike the international health regulations, are not binding. The WHO may express concern if states adopt additional measures that unnecessarily restrict international trade and travel, but there's no sort of method in which the WHO could enforce such to remove the additional measures that are unnecessary. So this particularly, the fact that these international health regulations are not binding may be particularly relevant for investment disputes and the legal weight that an investment tribunal may give to these regulations. What we are likely to see in investor-state disputes is that these, the international health regulations and temporary recommendations will be strong factual weight examples that will be relevant to the technical standards and scientific evidence of the measures, such as being used in the Philip Morris decision. And they may also be relevant to assessing when an emergency exists for the purposes of a necessity plea. However, these will be very complex factual situations to consider, and since the recommendations are not binding, where states depart from those recommendations, there's quite a potential for tribunals to take very different stances on the weight of these recommendations and the state's additional measures. So that's just an example of how the international health regulations might be brought in, sort of factual examples, but there is also the potential for these regulations and recommendations to be brought in under sort of interpretative guidance or the applicable law of a tribunal. And this is where it may get particularly uncertain and difficult for tribunals to sort of maintain a consistent approach to the international health law. So this comes about because of there's a significant uncertainty in investment law scholarship in relation to the extent of the adjudicatory power of tribunals to refer to other law and rules outside the investment framework. So just to provide a very short summary of some of the issues in the scholarship, because I certainly don't have time to go into all of the jurisdiction, applicable law and interpretation issues that my sort of PhD research covers in a lot more detail. But there is certainly this certainly there will be areas in which the investment tribunals could depart from one another and change what extent they find that international health law to be relevant in each of these sections. So for jurisdictional issues, we see that jurisdiction is limited, which leads to this tension between state consent and the broader normative framework. And how the tribunal may interpret the different types of jurisdictional clauses could lead to different ways in which they find the international health regulations to be relevant. Now, when we turn to applicable law issues, while international law is often included in applicable law clauses, this doesn't necessarily provide adequate guidance as to how applicable law should be, how the other international law should be integrated into the wider provisions of the BIT. And we can see that when there is often, in terms of the applicable law issues, inconsistent decisions of tribunals, which we can see coming out of the different decisions on how countermeasures under international law were applicable under NAFTA or not. In terms of interpretation, this is potentially where international health regulations will be most relevant and could come into the tribunal using systemic interpretation under Article 31(3)(c) of the Vienna Convention, which would allow the tribunals to incorporate other rules that are relevant. However, again, the tribunals will have to, there is a lot of caution and uncertainty in the scope of systemic interpretation. And tribunals such as Grand River in USA have cautioned against using it as a license to import legal elements from other treaties to allow alteration of an interpretation established through the normal interpretive process. So, as you can see from that very short summary of issues identified in the jurisdiction, applicable law and interpretation scholarship, is that we have to be very clear about how states and tribunals seek to use global health law. If it is simply as sort of a factual evidence, then this might be quite acceptable, as well as the interpretive guidance on what might be in the public interest and what does global health mean. However, it will only get more complex as the international health regulations and recommendations start to potentially impact a jurisdiction and applicable law in these disputes. So this shows some of the potential for fragmentation on how tribunals could consider the relevance of global health law to the potentially coming investor-state disputes. So turning to the second part of my presentation, which is looking at the regulatory powers doctrine. So to date, there has been very limited opportunity for investor states to consider public health concerns, and the most relevant being Philip Morris versus Uruguay. So Philip Morris gives us quite a lot of comfort that the international health regulations may be relevant to determining these potential disputes relating from the global health pandemic. Particularly in relation to the fact that Philip Morris illustrates that the protection of public health is an essential manifestation of a state's regulatory powers, and the fact that Uruguay there relied heavily on the Framework Convention on Tobacco Control to support its claim that to support its claim on the use of regulatory powers for the expropriation and breach of the fair and equitable treatment obligation. However, there is a potential important distinction between the Philip Morris case and the global pandemic cases that could lead to some uncertainty on how we can rely on this sort of guidance and comforting use of global health law in the Philip Morris case. And one particular issue is that Uruguay had specifically incorporated that international law through its domestic law and through its constitution. So this could lead to, and quite often we might not find that states have done the same thing for the international health regulations and the recommendations. So this could lead to further departure from global health law as to how tribunals decide to deal with the regulations and recommendations under the in the dispute. So I recognise I've was a little bit too ambitious in how much I wanted to cover in my presentation. So I don't have time to discuss the plea of necessity. But I just would like to simply point out the main issue in terms of the potential for fragmentation between tribunals and within the sort of overarching international law framework is the relationship between the BIT exception and the customary international law plea of necessity. Following the Argentine financial crisis, there was a significant inconsistent jurisprudence. While this, it seems that we might be a little bit more certain that the tribunals will take a sort of a lex specialis approach to this issue. There's still some significant questions relating to how the more restrictive customary international law plea will affect the interpretation of the BIT defence. So this unprincipled approach to the examination of the necessity defence in international investment law could lead us to further inconsistent jurisprudence in the global pandemic cases, as well as fragmentation concerns and even more backlash against investor-state dispute. Thank you for your time. I apologise I wasn't able to finish my entire presentation, but I look forward to your comments and questions.
Thank you very much, Nicole. What I'm going to do is go through everybody, and then hopefully at the end we'll have our missing or lost final commentator. If not, I'm going to ask Jonathan to assume both roles, i.e. comment on a paper, but also to present. Is that reasonable if we can't get her? Okay, introducing you now to Mr. Shwagodeep Sakha of the Indian Institute of Technology in Kharagpur. Abstract title is India Health-Related Regulatory Measures and Investment Treaty Arbitration. Can police powers doctrine be a knight in shining armor? Like that. Shwagodeep holds his BA LLB from the University of Calcutta and obtained his LLM in International Law Organizations from the Tamil Nadu Dr. Ambedkar Law University in Chennai. He's a PhD candidate at Rajiv Gandhi School of Intellectual Property Law, India Institute of Technology, Kharagpur. His research areas are international investment law, international commercial arbitration, peaceful settlement of international disputes, international courts and tribunals. He's also a member of the Asian Society of International Law. Shwagodeep, I introduce you, and please do go ahead.
Thank you so much for introducing Professor Truckman. So without further delay, I will start my presentation. So my paper topic discusses how police power doctrine could be used to avoid liability of paying compensation. Compensations might arise out of stringent measures India adopted or India might adopt its domestic health care system and to preserve its economy. At this time, have a scientific way of discussion. I would like to divide this talk in few sections. Like I will first introduce the context, then role of FDI in Indian healthcare system. Moving on to substantive breaches of BITs, then what kind of treaty claim India investor could raise. Then what do you mean by police powers doctrine? Police power doctrine, how shaped by investment tribunals? Then I will come to the question whether public health exception does fall within the scope of police powers. At last, I will analyze Indian BIT regime and how far that particular provision of of police power is incorporated in Indian BIT regime, and whether the police power doctrine absolute or it has some kind of limitations. So these are the things I'm going to discuss. To introduce the topic, I would say since outbreak of global pandemic, around 20 million people have been tested positive and around 1 million deaths are recorded. India is no exception. We are witnessing around 60,000 per day cases, and more we test and more we have corona positive cases. So like any other government around the world, Indian government is taking some drastic measures, and some of these measures like national lockdown, temporary closure of international borders, banning of exporting certain medicines, medical equipments, it gives incentives to importers importing medical devices and some kind of medicines. So these measures, these measures actually have some potentiality to breach investment treaty, both positive and negative way. Coming to the question, role of FDI in Indian health sector, I would like to point out what do you mean by Indian health sector? That Indian health sector consists of hospitals, medical devices, diagnostic centers, clinical trials, telemedicine, which is a very new phenomenon in India, medical tourism, health insurance, etc. And its projected growth rate is around 372 billion by the end of the 2022. India received 6.3 billion FDI in hospitals and diagnostic centers during June 2019 to April 2020, which consists 1.4% of its total FDI during that particular time. 100% FDI is allowed in greenfield project through automatic route, and 100% FDI is permitted in brownfield project through government route. And one of the interesting thing is that India is the fourth largest device market in the world, and which could reach around 11 billion by 2022, and which could exceed US 14 billion by the end of the 2025. So we know that how important FDI plays in Indian health sector. Now coming forward to the question, what kind of substantive breaches these measures which India is adopting or India might adopt in future could affect. So we know that FCM treaty, that is a first generation BIT, which actually originated to protect economic interest of foreigners abroad. New generation BIT, which consists of more than 3,000 bilateral investment treaties. These are no exception. Both are actually give protection to foreign investors or foreign property, both substantive way and procedural way. In terms of procedural protection, any investors can bring directly again can bring any claim directly against a state without any further approval from that particular state. On the other hand, substantive protections in terms of national treatment, rules against indirect expropriation, fair and equitable treatment, full protection, security, these are the some kind of standards and protection usually investors get from the particular investment treaty. But the measures adopted by India to contain COVID-19 and to protect its economy breach a rule against indirect expropriation and fair and equitable treatment more than any other rule of protection incorporated in the BIT. Coming to the question of what do you mean by police powers and how police power is shaped by different tribunals. I don't have much time to discuss each and every cases, but I will give some snippets. Like according to Adam Smith, police, the term is French and originally derived from the Greek word politia, which means that the policy of civil government. So apparently this meaning is pointing to a far-reaching concept like state's regulatory power to maintain cleanliness and security. Black's Law Dictionary gives the same meaning, like inherent and plenary power of a sovereign to make necessary and proper laws inter alia to preserve health and security. So in international law, it is settled probably or perhaps a customary international norm that property of alien cannot be confiscated or taken away, whether for public purpose or not, without adequate compensation. So states have to pay adequate compensation, whether it takes property or confiscate property. Without giving adequate compensation, it cannot take away property from the aliens. On the other hand, police power doctrine internationally implies that state regulatory measures which are apparently lawful exercises of state sovereign or regulatory powers may adversely affect foreign investment without amounting to expropriation. So these concepts are both opposite to each other. But it is very difficult to draw a line between a compensable indirect expropriation and non-compensable regulatory state measures. And it is the discretion, or it is up to the tribunals to draw that particular line, which depends on particular circumstances and facts of the cases. So shaping police power by investment tribunals, how police power is shaped, it is a concept, and it is actually shaped by many tribunals one way or other. There are numerous cases which actually discuss police powers at length and fleshed out that particular doctrine. One of the earliest cases, it is Setco Incorporated versus National Iranian Oil Company versus Islamic Republic of Iran. In that case, that particular tribunal held that it is a accepted principle of international law that a state is not liable for economic injury, which is a consequence of bona fide regulation within the accepted police power of the states. Other cases, you can take example Saluka Investment versus Czech Republic, where the tribunal held that the state does not commit an expropriation and is thus not liable to pay compensation to dispossessed investor when it adopts a general regulation that are commonly accepted as within the police power of the states. The tribunal also held that it is a customary norm of international law or general international law. Now the question is whether the public health comes within the scope of police powers. Here I can give an old case, almost 100 years old case, like it's Mixed Claims Commission, German Venezuelan Commission, which held in Bischoff case, which is decided in 1903. Particularly, I quote that line that certainly during an epidemic of an infectious disease, there can be no liability for the reasonable exercise of police powers, even though if it is done by mistake. Another example, you can take Bokor Aquaculture Limited versus the Scottish Ministers. It is 2003 case, European Union regulatory case, where it was held that community measures adopted to destroy fish stocks was essential objective to protect actually general interest of community, and the absence of compensation did not actually disproportionate and it is not intolerable interference impairing the very substance of the right to property. Another case which is recently decided, Philip Morris case, which in unambiguous term held that public health, or to protect public health, state can make any kind of measure, but it has to be proportionate with the objective to be sought. Now, I will come to the question that whether Indian bilateral investment regime incorporated that particular doctrine. My brief analysis actually reveals that majority of the Indian bilateral investment treaties do not have such provision. Only 23% of the investment treaties contain that particular provision. And in incorporating that particular police power, India has adopted two methods. First is that particular police power provision is incorporated in a separate document called as protocol, and that protocol is annexed to the particular BIT. And another one is like it is a part of the expropriation provision. So we can see that there is only 23% of the Indian BIT actually incorporated that particular provision, and most of the BITs Now the question comes whether that particular concept is absolute or not. No, that particular concept of police power is not absolute. It has some kind of limitations, but complexity lies in ascertaining within which the police powers could function, and crossing that particular mark makes the doctrine inoperable, triggering the compensable expropriation. Here I have actually studied the cases, and I have a few kinds of, there are three approaches. I have, okay, so, well, please, can I get 1 minute? I'll finish it within 1 minute.
Go ahead, yeah.
Okay, so I have studied a few investment cases and found that there are three approaches which actually investment tribunals apply to see whether police power doctrine is applicable or not. First set of tribunals actually gives importance to the severity of the effect of measures and the degree of impact on the investment, such as SD Mass versus Canada and Methanex versus US. You can take an example, and do not actually takes into account of regulatory measures severity and degree of impact, like BLG Group versus Argentina. And third set of tribunals which actually wanted to strike a balance between the two opposite approaches. It is called proportionality review approach. You can take the example like WNC Factoring Limited versus Czech Republic, Philip Morris versus Uruguay. So we can see that on the police powers doctrine in investment arbitration, where the rule is specifically included, notwithstanding its status as customary international law, still it is the discretion of the investment tribunals whether to apply that particular rule in the absence of treaty provision. You can take example what Santa Elena Tribunal held, that whatever laudable measure you want to place, whether it is environmental and it is a domestic environmental measure or it is international environmental measures, a state has to pay compensation. A state has obligation to pay compensation. So here I can rest my case that India could rely on that particular provision of police power, but it has to be incorporated in that BIT or Ballot Investment Treaty. So I rest my case.
Thank you very much. What I'm going to do is I'm going to go directly to Lu Wang, my colleague, and have her comment. And then if we in fact have the return of our missing guest, then we will go ahead. Alternatively, Jonathan will fulfill both roles. Dr. Lu Wang is a member of the law faculty and the Herbert Smith Freehills CIBEL Center. She'll be commenting on the presentations. I haven't seen her a long time, as she's in India, as in China. She joined UNSW Law as a lecturer in August 2018 after completing her PhDs at University of Liverpool in the UK, as well as at Jiaotong University in China. Her primary area of research is in international and comparative economic law, with a particular focus on international investment law, international arbitration, state-owned enterprises, SOEs, and China's regulations of foreign investment and trade and investment. Dr. Wang, I hand over to you. Thank you.
Hey everyone, good time of the day wherever you are. It's good to see my colleagues and to meet new colleagues in the CIBEL Global Network Conference and Young Scholars Workshop, even virtually, when most of us are still working from home. Thanks to my colleague, Professor Leo Trackman, for the very kind introduction. And I was asked to comment on two illuminating papers on state measures to protect public health and their challenges and implications for the investment treaties and treaty-based arbitration. So first of all, my comment on Nicola's paper. Nicola, thank you very much for this very brilliant and timely exposition on how international investment law, including investment treaties and ISDS cases, interact with other international legal instruments, especially the global health law instruments. And I was extremely intrigued by the possible fragmentations you identified in your paper on the application of global health law instruments on investment law, especially the SDS regime. And in your paper, you try to highlight the inconsistent application of other international law and the subsequent impact on defenses available to respondent states. I was wondering if you could articulate further on the ongoing challenges in ISDS. And in addition to your observations, I was particularly interested in your views on how these challenges would influence on the ISDS reforms and what options for states to address the possible or even worsen fragmentations in arbitral practice. And will this lead to any significant challenges or policy shifts in investment policies makings at the international level? And I also find it particularly illuminating that you mentioned how other international law was used in arbitral practice, including being used as facts and interpretive guidance and applicable law. But I was wondering if there are any difference in arbitral practice if these instruments were invoked by investors rather than states, and how should tribunals approach to these legal instruments in each case, and if it's necessary and possible to clarify the scope and effect of these legal instruments. And I understand that your paper is a work in progress, so I am extremely interested in your views on the possible influence on the interactions between international health law and investment law. As you mentioned in your preliminary conclusions, that the fragmentations may indicate a need to reconsider how regulatory powers and necessity defenses are drafted in international investment agreements. So I was wondering if you could share more thoughts on how these issues could be addressed in future investment treaties. And in addition to addressing the regulatory rights of states in the context of pandemic and risks of ISDS cases, I was wondering if you will consider other policy considerations such as investment liberalizations and investment facilitations, which are also becoming very important for states to mitigate the economic downturns caused by the pandemic, and how these competing interests could be balanced in future investment lawmaking. And this question may be beyond the global health pandemic, as there are other controversial issues emerging in the investment law field, such as the protection of human rights and the environment. So I'm very curious about your views on how this may influence on the future international investment lawmaking. For example, will that lead to more treaty exceptions or carve-outs? And if so, will that lead to any departure from the primary objective of international investment treaties and investor states arbitration, and what are influence on future international investment law? So these are my questions toward your interesting and informative paper, and thanks again. And now I'd like to go ahead and comment on Swagdeep's paper. And again, very, very informative and illuminating paper. And I can see similar themes actually crossing your paper and Nicola's paper, which is not surprising given the emerging challenges for states in response to the COVID-19 pandemic and the risk of investment arbitration over state matters. And in your paper, you mentioned some measures taken by the Indian government would affect foreign investments in both positive and negative ways. And I was wondering, firstly, what is the role of FDI in India health sector, and to what extent it has been affected by the COVID-19 measures that are taken by the Indian governments, and whether these measures are taken to contain the virus, which it means to for the public health purpose, or to mitigate the economic downturn. I'm particularly interested in the evidence if there are any of the impact of state measures of FDI in India. And secondly, I'm very interested in your views on how this would influence on India's investment policies in the future, as I found you talk about the importance of the health sector in India. So I was wondering if you've seen any changes or shifts in Indian policies toward inward FDI in this critical sector. And given the divergence of state policies at the national level, I'm curious about your insights on the direction of India's policies in the context of the pandemic as well as post-crisis. And my other comments relates to the state policy, states' place power in arbitral practice and investment treaties. And I think there's no consensus or even general guidelines for debates and refinements on the scope and in detail of a state's place power. And expropriation carries out in the exercise of a state's policy powers is a regulatory taking that does not amount to an indirect expropriation and is therefore non-compensable. And in your paper, you identify 3 approaches to place power in arbitral practice. And I was wondering, in your views, how will future tribunals approach to place powers, and what are the implications for investment treaty making? And you also mentioned 2 examples in India's bilateral investment treaties, and which actually clarified that in rare circumstances, non-discriminatory regulatory actions by state to protect legitimate public welfare objectives include health concerns do not constitute expropriation. So how would future tribunals apply and interpret these justifications as to India's current responses to COVID-19? And more importantly, I think I was wondering if the state's measures could be justified in such investment treaties. Should governments do need to suspend the ISDS claims on pandemic measures, as you argued in your paper? And this perhaps relates to my previous comments, as I think it might be useful to categorize the pandemic-related measures. And I was wondering how to identify the scope to pandemic-related measures in the context of post-crisis, and how will this affect the development of investment treaty regime, including the ISDS regime? And what are the implications for India investment treaty making in the future? So thanks again for your very informative and thought-provoking paper. Thank you all.
Thank you very much, Lou. Those were excellent presentations. Just checking, Jonathan seems to be almost back. Is it reasonable for me, for you to basically give us some insights, maybe take more than your 5 minutes and give us some perspectives on the paper? I assume that Apeksha is not joining us. I don't see her anywhere. Am I correct? Okay, if that's okay.
So Leon, Apeksha didn't actually send a paper through.
I saw she had notes. Is there nothing there to comment on, or?
Well, I'm happy to comment very briefly on the notes. They're quite brief, but essentially her notes indicate that her presentation would have been about restrictions on FDI, and I took that specifically to relate to FDI screening mechanisms established by various countries. That's something we've actually seen before the pandemic, a growing trend in the EU in particular, and greater, more aggressive use of the CFIUS investment screening mechanism in the US prior to the pandemic, and then a sort of further expansion of those mechanisms, potentially, well, in some countries in response to the pandemic. What I was interested to hear about, I guess, was how she would have understood, you know, she's highlighted questions about what are the sort of political agenda and the effects of these mechanisms, and I would have been interested in that because one thing I found quite unsatisfactory in a lot of the scholarship and commentary on those mechanisms so far has been a pretty uncritical approach to where the sort of national security interests actually lie in relation to foreign investment. What do we even mean by national security? Who's entitled to define that in a statutory context? What's at stake? How do they relate to domestic political economy factors, which seems to be a major driver of FDI screening in many states? So I would have been interested to hear her talk about some of those questions, but it's not clear from her points what her argument would have been beyond the sort of important observation that she makes that this is a phenomenon that is occurring. Since I'm here, I might just very briefly say something about the other three papers that doesn't go to substance, but just goes to presentational factors, especially since this is a sort of early scholars workshop. I thought all three presentations were fantastic. I thought they were interesting. I thought they all focused on really timely and important issues. So congratulations and well done. And it's a pleasure to be able to join in an event like this. One of the pieces of advice I wish I'd had as a student, and it's something I think Joseph Weiler, former editor-in-chief of the European Journal of International Law, wrote a series of really excellent blogs of advice to young scholars in international law. If you haven't read those, you should. And this is where some of this advice comes from. But when you give a presentation, it's really helpful if you can distill the key points of your presentation as clearly as possible for your audience. And in particular, when you've got an audience like this, where all of the young scholars are working in a similar area and all of the academics, I mean, you can look up our bios, you'll see we're all working in the similar area of international investment law. You can assume a sort of basic level of literacy in some of these concepts. And with an audience like that, where there is some assumed basic knowledge, it's really, really essential that you make it clear how your presentation relates to the existing literature on a topic. So with a lot of these discussions, it was like, so with everyone, so just to pick some, with Nicola's presentation, I mean, it was really wonderful. These are such important questions, but it wasn't, I just really didn't get the key sense of, we've already got these debates about treaty interpretation and fragmentation, including external norms and public health. We've got these debates about the interpretation of treaties' necessity clauses. We've got debates about applicable law. You're the one who's the expert in this. You've got all this knowledge. what's the like really new thing that people have missed that you're bringing to this discussion? And I wasn't sure. I thought maybe the sort of question of seeing some of these regulations and standards as fact rather than law was something I hadn't heard. Maybe I missed it in the literature, but that's not something I'd heard a lot about before. So if you see that as maybe one of your really new additions that people have just kind of completely missed the point before, and you've got something new to say, I would really highlight that aspect and sort of just drop away a lot of the background discussion which just sort of goes over issues that have already been covered in a lot of detail in the existing literature. And similarly with Swadeep, I sort of, I mean, this is very close to home for me. There's a chapter in a book I wrote in 2014 about some of these different interpretations of police powers and indirect expropriation. And even when I wrote that then, I was already trying to build on a very, very like established literature. So I'd love to sort of hear more clearly, like what's new in what you're bringing. These discussions are still important. There's still more new to say. But what is it that you're bringing that's sort of contributing to this? And, you know, I thought that your reference to Adam Smith, that was something I hadn't heard before. Maybe you've got a more historical approach than has been used in the past, and that's something that you're really adding. The question of export restrictions under the investment regime, it wasn't exactly clear to me how that would play out in practice. And you sort of passed over it, and there was another example of something at least I'm not as familiar with in the existing literature, and it may well be something that just, you know, you've got something really new and important that you've identified here as an issue, and then focus your presentations around those things and sort of just build off where existing scholarship has got to, sort of much more briefly as a kind of part of the setup of the presentation, but the main meat of the presentation on what's new, why it's interesting, how you approached it and why that matters. So that's, I guess, some advice about you know, conference style speaking that's sort of, I hope, relevant to everyone independently of the content of what you spoke on. But thanks so much. I really enjoyed that, and I thought they were all great.
Thanks, Jonathan. I think that's very, very useful, and I think it's excellent advice. It's a question of significance, I find, across the board with young scholars, and to some extent with older scholars too. We constantly have to remind ourselves of the things that Jonathan said. In terms of questions and answers, I hope that people are putting questions and answers across. Let me just make one. Oh, you're back. One broad question, and that is, we've all assumed that we have a new world, and just to go back to Kienda's original comment, the new world is one that was created by force majeure, circumstance beyond control, unforeseen, etc. The issue is, do we assume that this state of circumstance continues? In other words, do we have a beginning and an end? We are basically talking about an epidemic. We're talking about a global rather than a regional or local crisis. We're also talking about something that has variable impact. Australia, even though we're in lockdown in Victoria, is very limited compared to many other countries. India for one, United States for another. China, again, less so, despite the commentaries not enormous. So to what extent is this something that needs to have some sense of an endpoint? And do you say it's unforeseen if we talk about what the situation is in 2 years from now? In other words, do exporters and governments, are they able to invoke the necessity dash force majeure dash denial of investor protections on some ongoing basis in respect of something that is no longer not reasonably foreseen, but precisely the status of the problem is not particularly clear? And I think that is something that a contract lawyer and a treaty lawyer engaged in the area needs to think about. And it's also something that should be advised to clients that very often isn't. I mean, I can give you my predictions of what I think the world would look like in 2 years from now. Will it be a pandemic? Will it be something different? I honestly don't know. But I just think those are common denominator questions which are very difficult to answer, but they perhaps foreclose the idea that we can use the exact same arguments next year and the year thereafter that we've used now. Okay, so I'm going to look at the questions and I'm going to just see how much time we have. Where are my questions? Chat questions or, sorry, do we have chat questions? Gosh, show conversation. Okay.
Just in the Q&A.
I've got it right here. Let me just, sorry, I'm working with not my own computer. My computer took a, okay. I think maybe what I would do is start with the, I might actually just start off by asking, this may be an idea. Brooke asked some questions initially in her presentation, in her moderation, and I just wondered if that might be a good thing for Kayenda to start off with as a set of questions, if that's okay.
Perfect.
Thank you very, very much for your comments, Dr. Marshall. They were very, very helpful comments, and I think, I mean, you really, really hit the nail on the head. So basically, the 3 questions you asked me, I would categorize those 3 questions around 3 main themes. And the first theme is the distinction between purely commercial disputes and international investment disputes. So and then this has a historical context, and it also has a contemporary context. And the only way we can truly understand how force majeure operates is if we look at it from a historical context. So historically, the force majeure clause emerged in the context of war. And a century ago, there was nothing like international investment arbitration as we have it today. What we had was state-to-state dispute settlement. So we had mixed claim commissions. We had the Permanent Court of International Arbitration, which is the predecessor to the Permanent Court of Justice. And essentially, in these kinds of disputes, for instance, after a war, there will be a war, and then after the war has ended, the state would institute the claim on behalf of its nationals. The national didn't have the direct access to international arbitration. However, in the 1950s, there was a shift, and we saw the emergence. We had, specific. So, well, this shift sort of occurred in the context of colonization, and the force majeure clauses that began to emerge during this period made reference to principles of international law, general principles of international law. That was all that was stated in this contract. For instance, in the Sapphire case, the Sapphire case is one of the cases, and in this case, on the basis of the force majeure clause, which made reference to general principles of international law, the tribunal decided that the case was an international dispute, even though there was reference to national law. So there was reference to national law in the contract, but because there was a force majeure clause which made reference to general principles of international law, the contract was elevated to an international dispute. So how does this operate in practice? The way this operates in practice is you have a contract, for instance. If that contract makes reference to ICSID jurisdiction, even though there is no investment treaty, by the virtue of the fact that it makes reference to the ICSID Convention, Article 46 of the ICSID Convention allows tribunals to decide disputes on the basis of international law and national law. So what you have operating is sort of a diffusion between national law and national law. Now, this is not national law in the sense of, it can be any form of, I mean, it's national law very, very broadly. So it can be national law, for instance, Chinese law, and then the tribunal has to look at what Chinese law states, what the Chinese principle, what the Chinese law is on contracts and force majeure. So because we had this problem in the 1950s and in the 1960s, in the 1970s, standard investment contracts were drafted by ICSID. And specifically, Philip Kahn, who was one of the people who was involved in this standard investment contract, specifically stated that because the jurisprudence was undeveloped, there was no jurisprudence, it was very, very limited jurisprudence, that they would have to make reference to general commercial law. So what you have is commercial law was sort of transplanted into a very different regime. And so this is what we have in existence. Now, in contemporary times, there is sort of an artificial distinction between purely commercial disputes and investment disputes. So for instance, in an investment treaty dispute where there's a bilateral investment treaty, you would think about principles of fair and equitable treatment. You would also think about customary international law. But in a purely contractual dispute, there is no international investment treaty, but customary international law may be applicable. So these principles are very, very, very unclear. And like most of the other presenters have said, the reason why we have so much uncertainty is because the principles of law develop very, very slowly, and arbitral tribunals make a law, they perform a lawmaking function. So the law emerges from arbitral jurisprudence. And in the absence of arbitral jurisprudence, there's almost no law. It's very, very difficult. There's so much uncertainty. So definitely, I think the COVID-19 crisis, like you mentioned, the COVID-19 crisis would help us to think about how we can move forward and how we can fill some of the gaps which continue to exist in the law. Thank you.
Thank you all. There are a few more questions, but there's no real time. So I'm going to pass on that, just to indicate that it's been a great pleasure. I hope maybe someday we will actually see each other in person. And if I might volunteer on behalf of everybody, when I was a young scholar, I got involved in one of these, and I found that I identified mentors and people that I maintained contact with, fellows, and some of those have remained for the course of my academic life. So Jonathan's comment is we should get feedback on a regular basis, not just as young scholars, because we fall in and out of holes and rise up above them. So let's hope this to be a beginning and not an end. So the best of luck to all of you. Great appreciation. I think there was excellent products, and I think Jonathan's comments are ones you should take seriously as well. Thank you, and speak to you and see you in the next session. Thank you all very much. Goodbye.
Thank you.
Thank you.
Okay, bye-bye now.
Bye.
Thank you all.